Good evening. On behalf of the Clarke Forum and Betty and Dan Churchill, I would like to welcome you to tonight's event, Guantanamo and the Nation's Narrative, From Enemy Combatants to Lawfare. My name is Pete Nanov, and I am one of the student co-supervisors at the Clarke Forum for Contemporary Issues. While it is difficult at this point to evaluate the success of the War on Terror, we have not had a post-9/11 attack on United States soil. Throughout the operations of this war, the Department of Defense has been detaining individuals captured in the War on Terror at Guantanamo Bay Naval Base since 2002. In the Bush administration's attempts to take the battle overseas and away from the United States, the country has been subject to a different type of battle, those that take place in courtrooms. Such battles include Rasul v. Bush, Hamdi v. Rumsfeld, and Hamdan v. Rumsfeld. To this point, the lawfare battles have been a war of attrition, with the Bush administration's power to indefinitely detain and interrogate captives slowly being taken away. This past June, the Supreme Court decided Boumediene v. Bush, ruling that prisoners detained in Guantanamo Bay do in fact have the right to challenge their detention in federal courts of the United States. The Supreme Court's involvement in executive war-making raises important questions regarding the standard to which the executive is held, as well as the role of the judiciary in foreign policy and war. Our guest tonight, Professor Richard J. Wilson, is the founding director of the International Human Rights Law Clinic at American University's Washington College of Law. During his career, he has represented 3 Guantanamo Bay detainees and has visited the base numerous times. Since 1990, his clinic has regularly litigated cases involving transnational and international criminal law in domestic and international courts or tribunals. In addition, he is a director for the Center for Human Rights and Humanitarian Law, as well as a professor of law at American University. Additionally, Professor Wilson is the president of the board of directors of the World Organization for Human Rights for the United States of America. He also appeared as an expert witness for the defense in the capital trial of Lee Boyd Malvo, one of the convicted Washington snipers. At this time, I would like to ask that the sound be turned off on all cell phones and any other electronic device. In addition, please hold any questions until the end of the presentation, when there will be a short question and answer session. Out of courtesy to those who may be hearing impaired, and because we are taping this event, please raise your hand and wait for a mic to be passed to you before speaking. Thank you for your cooperation, and now please help me in joining Professor Richard Wilson.
Thanks so much, Pete. And Pete's been guiding me around campus today, and I can't tell you how terrific it's been to be here and how well cared for I have been in preparing for this event. We just shared a wonderful meal, and I want to thank Professor Harry Pullman for his hospitality and his staff for all their help in getting me here and making this event possible. They've made it as easy as one can imagine in getting here and making everything run. My biggest challenge is going to be technology. That ask any of my students, and so I'm going to try to do a little mixed media here, but you may have to bear with me. I have given probably more talks on Guantanamo than any other topic in my more than 35-year legal career. As a public defender first, then a representative of public defenders in the National Association, and finally as a law teacher at American. And it has been the most challenging area of the law, the most difficult case, and I'm speaking about one case in particular, that of Omar Khadr, a young Canadian captured at age 15 who ended up at Guantanamo at age 16, who I represented from about July 2004 until mid-April 2007, and now represent 2 more detainees there. But the longer I do this work and the more talks I give, the less interested, I would say, I am in doing the sort of parsing of the legal issues in these cases that are so fascinating to law professors everywhere. And law professors dream of cases like this coming along so that they can look at them from every angle and think about the intersection of the law of war and human rights and domestic law in ways that have never been thought about before. And I don't want to do that tonight. I think the longer I do this, the more I find it myself focused on the issues of the prisoners themselves and the issues that face them. The narrative on Guantanamo is changing, and the narrative has evolved. And if I can, well, I'll talk a little more then. The bulb. See, no, it's not even me. It's a conspiracy. The work that I have done in Guantanamo, as I mentioned, began with representation of Omar Khadr, which ran for about a 3-year period. In 2007, Canadian lawyers took over his case as civilian counsel, but as you may be aware, all of the detainees who are charged by military commission are required to have military lawyers represent them. And one of the eye-opening opportunities for me was to be involved in a military commission proceeding with Omar Khadr and to work as co-counsel with military lawyers from the Marines and the Air Force, in my case. I also met and worked closely with a number of servicemen and women who were involved in the representation of detainees. And I think all of us were skeptical as lawyers as to whether or not the military would do the job necessary, and many civilian lawyers were skeptical of whether or not an appointed military lawyer would be dedicated to the client's interests before a military tribunal. And I can tell you unequivocally that these are some of the finest men and women I have ever worked with, and that they were unstinting in their loyalty to their clients and to their representation of Omar Khadr and of the other detainees who face trial by military commission. And I think, as you'll see as the evening goes on, when we talk about the situation of another detainee who has gone through a military commission trial, that the military has acquitted itself very well at the operational level with regard to those men and women who have served as judges and juries in Guantanamo Bay. I also represent now 2 other prisoners, Salem Garebi, who is from Libya, and a man named Polad Sirajov, who is from Azerbaijan. Polad is the only person from Azerbaijan. I've been to Guantanamo about 12 or 13 times, and I went in August of this year to see Salem Garebi for the first time, and he refused to meet with me. And I was frustrated, as all lawyers are when their clients decline a visit. But I absolutely understand why a detainee would lose faith in lawyers, lose faith in law, that law would make any difference at all. So I swallowed hard, and I'll go back again to try to meet with Mr. Garabi. I will go in October to meet with Mr. Sirajov, who has asked for a lawyer for about 2 years, but because of the legal tangle in the courts in the United States, no judge would rule on his case to permit me to go until the Boumediene decision in June of this year that kind of broke the logjam and opened the opportunity to be able to go to meet with him in October for the first time. So this man who has waited for 2 years will finally see a lawyer, and I have to tell you, I feel a good deal of nervousness, a good deal of trepidation about finally meeting with him and saying to him what he might be able to hope for given the state of play with regard to Guantanamo Bay in the legal arena. We've had exchanges of correspondence that take about 2 months in each direction because of the necessity for going through secure facilities and vetting for the presence of what might be either coded messages or subversive material or potentially destructive devices in attorney-client correspondence. So the process is a daunting one for any lawyer who undertakes the representation of a detainee at Guantanamo Bay. Tonight I want to ask 2 questions. I want us to look at who are these prisoners at Guantanamo, and I want to look at the question of who are their lawyers and how are they perceived and what effect have we had in law? What has law done for the prisoners at Guantanamo? First of all, who are these prisoners who are colloquially called detainees, one of the many euphemisms that's used in connection with incarceration at Guantanamo Bay, and the vocabulary with regard to Guantanamo Bay is rife with these kinds of euphemisms or acronyms that are used to soften the terminology that applies to a very harsh regime of detention and interrogation. The number of prisoners at Guantanamo Bay now has dropped to about 250 from a high of over 700. So there have been about 500 releases from Guantanamo Bay. None because of the action of a lawyer. All because of government decisions to transfer individuals back either to their countries of origin or to another country. Some 20 or so of those 250 who still remain there have been found to be NECs, N-E-Cs, no longer enemy combatants. Individuals who are no longer a danger to the United States, but can't be taken out of Guantanamo because there is no one who can take them, and we won't send them to their home countries. A paradigmatic example is the Uyghurs of Western China, who are in conflict with the Chinese government. And if they were to be repatriated to their home territory, they would in all likelihood be arrested on the tarmac and executed. So they can't be sent back to China, they can't come to the United States, and no country will take them. So they stay in Guantanamo because they have nowhere to go. Another few, now about 12, face trial by military commission, including our former client Omar Khadr, who you may read about in the news. He is occasionally in the news as his case winds towards trial. And another dozen or so including the high-value detainees who were moved from clandestine sites around the world to Guantanamo just after the Hamdan decision, in an effort, in my view, to kind of raise the danger level of the detainee population at Guantanamo Bay so that trials that were going to be held under the new military commissions system would have defendants who really raised a risk for the United States, because many of the detainees do not, in any sense of the word. Guantanamo was, I think, unquestionably designed as a place where interrogation could be conducted freely. But overtly, it was designed as a place to hold prisoners pending their trials. Of those 700, one can see easily that only a dozen or so face military commission charges now, and the government tells us that of the remaining 250, only a maximum of 60-some may be tried by military commission. So of the 700, less than 10% will ever face a trial. The rest will undoubtedly be released somewhere along the way or go through habeas corpus proceedings in the United States that will determine the legitimacy of their incarceration. All of the detainees have the right to habeas corpus in the United States, and all of them have venue just down the road in Washington, D.C., in the federal courts of Washington. And some 250 lawyers, more, maybe 400 now, have volunteered to represent these individuals. Some of these lawyers from large law firms who donate their services. None of us are paid. None of us receive a cent for our representation. All of us do the work because we care about the principles of justice that are in play for all of the Guantanamo detainees. There is a decision from the U.S. Supreme Court in June. Pete mentioned the Boumediene decision, which requires that all of the detainees have the right to habeas corpus and that all of them will be able to have their cases heard in one way or another in federal court in Washington, D.C. These cases are now in the very early stages after this decision. Things move very slowly in the law. So from June until now, we are still only in the very early skirmishing stages of sorting out what's going to happen with these cases. And it has, and I know my colleagues would condemn me for saying this, but it has made it very difficult, I think, for the government, with a very small office at the Department of Justice, to respond to the demands of these 250 cases that are now all on the docket at once and all ready to move forward in habeas corpus proceedings. So the order of the Supreme Court that says that they have a right to habeas corpus is playing itself out. Many of the cases have been consolidated before a single judge, as happened the last time when these cases were first appeared in the federal courts. So some 200 are in front of one single judge for preliminary issues. And a couple of judges have kept their cases, one very conservative judge who's likely to rule in favor of the government, and one very liberal judge who's likely to rule in favor of the detainees, have kept their own cases as they are able to do in using their judicial prerogative. So we have a big cluster in the middle, one on the right and one on the left, and in all likelihood the decisions from these judges will vary greatly. They'll create conflicts at that level that will require appeals to resolve those issues, and so the litigation will go on and on and on in law. We're back up again. The issues around And no sooner do we go up than I'm going to go off intentionally. But I don't think I can work without it, so I think I'm going to have to move back here. I want us to take a look at the way that Guantanamo Bay is portrayed in popular culture. Some of you may have seen this movie, but this is the Guantanamo Bay we see in
Flight 420 to Amsterdam, now boarding at gate 13.
Sir, I need you to step aside, please. Just a random security check.
Random, huh?
No. Come on, just do what the guy says.
You were racist?
Racist? Dude, I'm black.
He's black. He's not racist. Please. You're barely even brown.
In 8 hours, we're gonna be in Amsterdam. This is amazing. This is bigger than I thought. North Korea and Al-Qaeda working together.
We're Americans, man. We love America.
Hey, zip it, Hello Kitty.
Welcome to Guantanamo Bay. You boys like to spoon?
No.
All right, that's enough of that one. The issues around Guantanamo may seem comic, but oh my goodness, now we are lost forever. And I'm not finding. Yes, I am. But the more serious side occurs in the interrogation of Omar Khadr, and the Canadian lawyers who worked with him had the distinction of obtaining the release from the Canadian courts. No U.S. court has ruled this way. To obtain the first footage of an actual interrogation at Guantanamo Bay, in this case of Omar Khadr, who was our client. He is age 16 in this video. He is meeting with Canadian officials for the first time in this video. And I want you to watch this little excerpt on YouTube, and then I'm going to tell you a little bit about it after we watch it.
How about we get together tomorrow for a talk? All right? Yeah, it's good to see you.
In fact, it's not at all.
Tell me what you think.
No.
My arms, I'm all these areas healthy.
No.
It's healthy, I can't move my arms. I requested medical for a long time, they don't know anything about it.
No, I mean, they look like they're healing well to me. You know, I'm not a doctor, but I think you're getting good medical care.
No, I'm not. You're not here. I'm right back.
Take a few minutes, relax a bit.
This clip, which is a small part of about a 7-hour interrogation, shows young Omar at first gleefully recognizing what he believes to be friends from the Canadian government. In fact, as you can see, and as the world saw when these tapes were released, the Canadian government wasn't there to help him, but to continue his interrogation. And once he realized that, and you can see his smiling face in the beginning of the video, as he says, at last, someone who cares about me. And at this point, he's still a year and a half away from seeing lawyers. He sees someone from his own country, Canada, an ally of the United States, and says, "You must be here to help me." They say no. He starts talking about the wounds on his body and describes the lack of medical care that he's received. And as he's stripping off his shirt, he's pointing to his shoulder and looking at the wounds that he acquired at the time that he was captured, when he was almost killed. He continues, and he breaks down crying. He's 16 years old at this point. He's been by himself in isolation at Guantanamo Bay for well over 2 years at that point, and spent a harrowing several months at Bagram Air Force Base in Afghanistan before that. He's left alone, and you can hear him saying at the end of the tape, I think there's some debate about this, but it seems to me that he is saying, "Kill me. Kill me." He said the same words when he was captured on the battlefield, lying as he was about to be treated by American medics, who, to their credit, pulled him back from near death, saved his life, and took him into custody. So the discourse on Guantanamo Bay both has entered pop culture, and it is still very, very invisible to us. This is the only tape we have of any interrogation at Guantanamo Bay. So we haven't seen anything like Abu Ghraib. But I think I can tell you, and I think many lawyers would tell you, that the techniques that were used at Abu Ghraib migrated there from Guantanamo Bay. So much of what happened at Abu Ghraib had already happened at Guantanamo Bay before. The same commanding officer was in charge at Abu Ghraib who was in charge of the interrogations at Guantanamo Bay many months earlier. So, the legal standard that deals with the holding of prisoners at Guantanamo Bay and justifies their detention is through a process that was invented by the U.S. government, not through the application of the traditional law of war, but immediately after the decision of the Supreme Court in the Rasul case in 2004, with a process called Combat Status Review Tribunals, or CSRTs, as everything is known in the military with an acronym. This process came into being after the Supreme Court's decision as a way to not apply the Geneva Conventions, but to have something that kind of looked like the process of the Geneva Conventions. And the outcome of that process was the designation or non-designation of a detainee as what is called, in the government's parlance, an enemy combatant. An enemy combatant. Let's take a look at the term enemy combatant and what it means and how it has come into play and how it has evolved over time. It's a term which sensibly and on the street means someone on the other side in an armed conflict, the enemy, the person who is fighting against us. And in a sense, it reflects that basic framework of the law of war that distinguishes between civilians and combatants. And that is the touchstone of the law of war. Are you a civilian or are you a combatant? If you are a combatant, you enjoy the combatant's privilege, which allows you to engage in combat and kill other soldiers and do so without suffering the consequences that you would in a normal situation in which you might be held responsible for murder. So if you are a lawful combatant, you can engage in warfare. If you're not, you are either a civilian or you are an unlawful combatant, not an enemy combatant. An enemy combatant is anyone who's on the other side. That's the common definition. But it is a term that in the United States has taken on legal significance that refers to both the personal status of the person, that is, if you are an enemy combatant, we can hold you, and it also talks about the length of the detention, and in that way relates again to the law of war, because enemy combatant is offered as a term that allows the government to hold you until the end of hostilities. Now, the question of when the end of hostilities happens is a very open one, and one that has not been resolved by any court. Which hostilities are we talking about? Are we talking about Afghanistan? Are we talking about Iraq? Are we talking about the war on terror, the long war? And all of those terms, all of those hostilities have come into play over the use of the term enemy combatant. The first context in which enemy combatant came into play was in the Hamdi case, the case of Yasir Hamdi. Who is Yasir Hamdi? Yasir Hamdi was a U.S. citizen born in Baton Rouge, Louisiana, arrested in Afghanistan for his alleged links to the Taliban, fighting against the U.S., taken to Guantanamo, held there for 3 years without charges, and then discovered that he was a U.S. citizen. He was immediately moved from that base because no U.S. citizen was to be held there, and taken to the United States, where he was held in Virginia and then in South Carolina. He moved away from Saudi Arabia when he was young. He was denied a lawyer, despite the fact that he is a U.S. citizen, was denied a lawyer based on his enemy combatant status for 3 years, then permitted to speak with the local federal defender only on condition that his meeting would be recorded against all rules of professional responsibility, and that he would not talk about anything to do with his conditions of confinement. His case went to the Supreme Court, where a key to the analysis of the court at the threshold, the opening paragraph, was, who is an enemy combatant? And this is the words in the majority opinion. The threshold question is whether the executive has the authority to detain citizens who qualify as, quote, enemy combatants. There is some debate as to the proper scope of this term, and the government has never provided any court with the full criteria that it uses to classify individuals as such. For lawyers, definitions are everything. And for this context, definitions are crucial. This makes the difference of whether this person can be held indefinitely or until the end of hostilities, whether this person gets treated in one way or another. This term, enemy combatant, floats somewhere between prisoner of war and captive, defendant in a criminal proceeding. Within 3 months after the Supreme Court's decision in Hamdi, which said, you got it wrong, this was an abuse of presidential power, this defendant is entitled to some kind of proceeding. Certainly U.S. citizens are entitled to some kind of habeas proceeding. Within 3 months after that decision, Yasir Hamdi was released from custody, deported to Saudi Arabia, after he agreed to renounce his U.S. citizenship and promised to restrict his travel to the countries just around Saudi Arabia. Yasir Hamdi hasn't been heard from since. One of the few who was released, at least arguably, because of legal action and because of the intervention of a lawyer. An otherwise invisible defendant behind the scenes. My second story has to do with who is Salim Hamdan. And many of you may know this story. Salim Hamdan is the only detainee who has faced a trial by military commission. One detainee before him, David Hicks, an Australian, pled guilty, was returned to Australia, and has since been released. Salim Hamdan was alleged to be the driver for Osama bin Laden and was charged originally with conspiracy and providing material support for terrorism. Those charges were struck down, and his case went to the Supreme Court, which struck down the military commission system. He was tried on new charges, the same charges, and a military jury acquitted him of conspiracy and convicted him of material support, and he was sentenced in August of this year to 5.5 years in prison, over the prosecution's recommendation that he be sentenced to 30 years to life. The military jury saw that Salim Hamdan was small potatoes, nothing serious, not the kind of hardened terrorist that we all believed were being held at Guantanamo Bay. And with credit for 61 months that he had already been held at Guantanamo Bay, he is eligible to be released from his prison sentence in January of this year, this coming year. Will he be released? Not likely. The government argues that he is an enemy combatant and that he will return to enemy combatant status and that he can be held indefinitely. Justice Kennedy pointed this out in his concurring decision, and in fact I think it gave him some comfort to rule in favor of the detainee, because it didn't really matter if he is tried and convicted, because he could still be held. You'll see that italicized phrase at the end. The government claims authority to continue to detain him based on his status as an enemy combatant. So that invented term, this term that didn't exist before it was invented by the U.S. government, in the law of war as a term of art, is now used to justify both the detention and indefinite nature of it. Finally, and this is one that I think has really not been talked about at all, who is Lawfare Boumediene? If we look at the decision of the Supreme Court in June of this year, we won't find a single detail of the story of this man. The court launches almost immediately into its analysis of the writ of habeas corpus, its history, the application in the law of armed conflict, and all of the precise legal details. And the story of the man is lost. And I'm going to tell you a little bit about him tonight. There is an oblique reference in the majority's decision to prisoners who are captured far from the battlefields of Afghanistan, in places, and I'm quoting now, like Bosnia or Gambia. Lawfare Boumediene is an Algerian who was captured in Bosnia, not in Afghanistan, and held by Bosnian officials at the request of the U.S. government. He filed for habeas corpus in Bosnia, and his case went to the Bosnian Supreme Court, and they ruled that there wasn't enough evidence to hold him. They released him, and as he walked out the courthouse door, U.S. officials picked him up, put him on a plane, and flew him to Guantanamo Bay. They didn't use any legal process. They rendered him, is the term that is used in the parlance of the day. Simply took him by force. Some would say kidnapped. He has been held there with 5 other individuals who were taken with him, and it was his case that led to the Supreme Court's decision granting habeas corpus to all the detainees. He and his other 5 companions from Algeria all have cases pending in the European Court of Human Rights that have to do with the legality of removing him from Europe after a decision from a a European court that said there was no legal grounds to hold him. So he is one of the few people who have proceedings going on in both Europe and the United States. So, these are some of the stories. And when we think about enemy combatant in the context of Lakhdar Boumediene, we're not talking about somebody who's fighting against the United States. We're talking about somebody who was captured, not involved in armed conflict, not involved in Afghanistan, but captured on some other ground in some other place. So the terminology, the fluidity, the ambiguity of the term enemy combatant continues. So how will history remember Guantanamo? Well, I am fond of a quote from Grant Gilmore, and another historian, which I think captures a sense of the place, Guantanamo. He says, "Law reflects, but in no sense determines the moral worth of a society. The better the society, the less law there will be. In heaven, there will be no law, and the lion will lie down with the lamb. The worse the society, the more law there will be. In hell, there will be nothing but law, and due process will be meticulously observed." Well, is due process being meticulously observed? I have to say, as a lawyer for a detainee, I have been heartened by all of these decisions from the Supreme Court. We now have 3. All of them a definitive rejection of the administration's positions with regard to its views of its powers to hold these individuals, their rights in the courts, the use of military commissions. We haven't had much yet on interrogations, but I think that will come. But, as I mentioned before, there has never been a court-ordered release from Guantanamo. Even the Hamdi case that I mentioned, where Hamdi was released, had to do with negotiations between governments. It wasn't because of a lawyer's advocacy that he was released. It was because 2 governments agreed that he could be released. So, 500 people have been released because of the actions of the government. They have argued that if the lawyers are permitted to do their work, people will return to battle, and there is some evidence that some detainees have returned to the battlefield. But let's look at the history. The releases are all because of the government's action, not because of the lawyers' decisions or the lawyers' advocacy. So if these individuals return to the battlefield, it's because the government decided to release them and take the risk that they would be going back to the battlefield, not because a judge has entered an order that says that they will. And the trial judges and the appellate court judges below the Supreme Court have been incredibly timid about confronting the government with its policies, about challenging it to define what it means by enemy combatant. There has been some movement with regard to that. As I mentioned, the term didn't have any meaning before its invention by the U.S. in 2002. The term has, by one scholar's count, at least 6 different definitions, including internally inconsistent decisions in the Military Commissions Act of 2006. In that act, they added the term illegal before it to make it sound a little bit more like unlawful enemy combatant, that brings it closer to the parlance of the law of war. And until recently, judges have not been willing to challenge it. We have these 2 decisions, a decision from the D.C. Court of Appeals in Parhat and a decision from the 4th Circuit in Al-Mari, that both are headed towards the Supreme Court that raise questions about who an enemy combatant is. How about those lawyers Well, I want you to take a look at this passage from the National Defense Strategy of the United States, published in March 2005. Under the section called Vulnerabilities, the National Defense Strategy says the following: our strength as a nation will continue to be challenged by those who employ a strategy of the weak, using international fora, judicial processes, and terrorism. Puts the lawyers right next to the terrorist. Judicial processes. So if we defend our clients, we are engaging in a strategy of the weak. I disagree. This is national policy. This is right from the National Defense Strategy of the United States. Air Force General Charles Dunlap, who popularized the term lawfare, a term that not many people know, describes it as a strategy of misusing law as a substitute for traditional military means to achieve an operational objective. He gives an example of having people hide out in a historically preserved building, a protected building, in order to claim later that if the counterattack destroys the building, that they've destroyed a relic and that they should be charged with the crime of destroying history. It's oftentimes made by those who hide amongst civilian populations and say, if you kill me, and you're going to kill civilians too, and that's a violation of the law of war. But another use of it was made by one of our Department of Justice officials, in which he argued that lawfare was expanding habeas corpus rights to prisoners of war, which would make warfare involving the United States more difficult, if not impossible. A rally on the Supreme Court steps in support of detainees' rights is something that looks suspiciously like an abusive form of lawfare through a naked appeal to our emotions. So now the First Amendment doesn't apply. The lawyers shouldn't make their arguments, and they shouldn't rally on the Supreme Court because that's a naked appeal to our emotions. I get angry when the good work of lawyers who are defending not just detainees, but the integrity of the judicial process comes under fire. It feels to me as though this is one of the most important jobs that can be done. Nope, it's not going to let me close down here. And as I think about what I say when I look into the eyes of my clients at Guantanamo Bay, what I say about what law can do for them, when I know that no court has ever acted to release one of them, despite the rulings of the Supreme Court, I wonder whether my actions are more effective than their own acts of desperation in which they use their own bodies. Guantanamo, says one of my colleagues who represented Omar Khadr with me over those 3 years, is about the body. It's about the body of the detainees. The detainees respond to their now 7-year incarceration. Omar Khadr turned 22 this week. Still has not been tried. They respond with A-bomb cocktails made from their own feces and urine that they throw at the guards. They respond with hunger strikes. They respond with many, many attempted suicides and, tragically, a few successful suicides. They refuse to participate in proceedings. They refuse to see their lawyers. And they write poetry. It's all they can do. They can't change their situation. Law will not act for them. So they write poetry. And I'll finish with a brief passage from a poem by one of the detainees that's collected in a volume of poetry called Poems from Guantanamo, The Detainees Speak, edited by another professor, Mark Falkoff. This is Abdullah Al-Ajmi, who writes a poem called To My Captive Lawyer, Amanda. Captive Amanda, my Lord knows that I have not given a thought to the paperwork that you sent to me. Let me tell you, captive, that our release is not in the hands of lawyers or the hands of America. Our release is in the hands of He who created us. Amanda, what can I say? The heart is incarcerated in prisons of injustice, tortured and deprived, targeted with every poisoned, sharpened arrow by the hands of oppressors who have no mercy on the oppressed. Tell the mother of my children about me, her youth who will not rise up for her. The prisoners shall walk out, and every brother in bondage, sold by the infidels, hooded and masked. I shall persevere until the Creator of the universe grants me relief, and I tend the sheep in the valleys where I roam. I say that the rope of injustice is weak and will end up being broken, will split and fall. Thank you. All right. We're going to take some questions, I understand.
Professor.
I think it's on.
Can you hear me?
Yeah.
Professor Wilson, I don't know if you mean to be critical of attorneys, but regardless of whether you do or not, I think everyone in the room can agree that we all, I think, would thank you for the work that you're doing, regardless of what we think of Guantanamo, the detention, or what it means for the law of the United States. My question actually, which at the end will really be more of a request for a comment from you, is in relation to a statement by a former judge of the highest court of Great Britain, whose name is Lord Steyne. He refers to Guantanamo Bay as a legal black hole. It looks like you're familiar with it. My question for you is if you would just be willing to comment on that description of Guantanamo.
Mm-hmm. I think he captured it exactly right. I used the term myself. I thought it was a brilliant invocation and a graphic way of describing what the administration intended. I think if we look, and now the history of the memoranda that had to do with the creation of Guantanamo and its particular position and its purposes, I think it was designed to be an offshore facility outside of the territorial jurisdiction of the United States and outside of the legal jurisdiction of the United States. Because it was the belief of those lawyers who designed the system that they could come up with a term like enemy combatant that didn't fall within the law of war and that could define these individuals as outside the law, that they didn't fall within the protection of U.S. law, they didn't fall within the protection of even Common Article 3, the most basic rule of the law of war, and that they were therefore fair game for interrogation. And I think I don't want to be too harsh in hindsight. I think at the time we were staggered. We were shocked by the breadth and intensity of the attacks of 9/11, and we wanted to respond to ensure that we wouldn't be attacked again. But I think our response went too far. My view is that Guantanamo is a kind of aberrational glitch that has sort of dug its place into our legal iconography and has become a symbol that I think tragically will be remembered as a stain, not an appropriate use of U.S. authority by history. And I think whatever efforts the lawyers have done have helped to both tell the stories of the Guantanamo detainees, which they would never have been able to tell themselves, and to bring their cases to the courts and get them as far as we have gotten. But I have to say, having gotten this far after 7 years feels as though the pace is glacial, and to tell that to detainees is very, very hard. So I think it was a legal black hole. I don't believe it is anymore.
Professor Wilson, what role do student human rights organizations play in trying to provide for the provision of due process for these detainees?
Well, you have an active amnesty chapter here, and I think there is some movement afoot to look to both changing the law, to closing Guantanamo Bay. I think the president himself has said he wants to close Guantanamo Bay. Both of the presidential candidates have said close Guantanamo Bay. I think that's the right idea, but of course the question remains, what do we do with the detainees who are there? And I think letter writing campaigns, which Amnesty is so good at, would be terrific, both to look forward to closing Guantanamo, removing those individuals, and I think urging Europe to take many of the detainees who are not at risk and where they can get safe haven that they will not be given in the United States. I think Europe is reluctant to do it because they feel as though the U.S. should do it, but the U.S. is not going to do it. So I think for the last couple of summers I've taught in Europe, and there are a lot of European professors who are saying it is our turn to step up. It's our turn to be responsible in this situation, and we owe it. We were complicit in some of the renditions of individuals across Europe. It's the least we can do. There are some people who I think need to be tried, and their guilt or innocence needs to be decided. But that's a very small number. I think they could be tried not necessarily by these military commissions, but by either military court-martials or in the civilian justice system, as Zacharias Moussaoui, Richard Reed, John Walker Lind, all terrorists of the same ilk have been tried, and as our criminal justice system has worked over and over again. So, letter writing, raise your voices, speak both to the future, and I think there's some movement on Capitol Hill to look at responsibility for the past as well. And I encourage you to look at that.
It seems that what has enabled, or at least one of the main components that has enabled this structural error to occur is the ability of the administration to insert the term of enemy combatant into the legal language. This ability to insert new language into a legal system seems like it does have some beneficial qualities in some situations for both prosecutors and defenders. But is there any test or procedure which could be introduced which would more effectively shape how new language could be inserted into the legal language that would make it more useful and prevent this sort of thing from happening again?
Sure, that's a great question. And I think there are ways to do that. I think, as I mentioned, the term enemy combatant is just a slither away from the traditional law of war. We have reference. We have the law of war. And if we look at the history of Guantanamo and the policies surrounding it and the use of the term enemy combatant, we see that both before Guantanamo and after Guantanamo, in the field, the military continues to apply appropriately the Geneva Conventions because it's not just the right thing to do, but it benefits our soldiers. We want to protect our own soldiers from the risk of having a regime apply something like this to them. So we use the law of war. We have a system for sorting out combatants and civilians when they're captured on the battlefield. It's a system that's been reliable, that we've used before and used since. I think it's totally appropriate. It is certainly a definitional touchstone. What bothers me is the fluidity, the ambiguity, the indeterminacy of the term enemy combatant. I would be happy, and I think those two cases that I mentioned are judges who are finally saying, no, you've got to be specific. You can use the term, and maybe it's a good term to use, but use it consistently. Use it in a way that instructs us about how to apply it appropriately and consistently in all circumstances. And I think that the touchstone ought to be in reference to the law of war. We should use the framework that we use with regard to prisoners of war and the trial of individuals who fall into the category of unlawful combatants who commit war crimes. So there is a framework. And a lot of folks say, well, it's a framework that's obsolete or inappropriate for modern times. But I think there is some truth to that because it's a rough framework. But if you look at the work of the military, and if, I hesitate to say this, but if the administration had listened to the rank and file military at the time that the decisions were being made about Guantanamo and the interrogation regime used there, and they had used the rules that were in play, I think we could have probably avoided the difficulties that we had. So my sense is that that regime was good then, it's good now, and it would have been good for Guantanamo.
Professor, I believe that we could all agree that history will see Guantanamo Bay as we currently see the internment of the Japanese during World War II. However, could you speak to the implications of allowing the Guantanamo Bay issue to go away without giving the courts the ample opportunity to actually resolve the issue of enemy combatants and allowing it to stay in our linguistic system for future use?
Well, I think it's getting sorted out. I think it's getting sorted out slowly but surely. I thought you were going to ask me the question about accountability that everybody asks. And I'm on your question. I think the courts are moving in the right direction with regard to giving some stability to the term and pinning the government down with regard to some consistency on that. And I think as soon as we depart from the law of war and start applying it around the edges to apply to individuals who aren't involved in active combat against us, then we're talking about people who are committing crimes in the usual criminal justice process. And we should be applying the criminal law and everything that goes with it in international criminal law as well. I got a new edition of a book called Understanding International Criminal Law. I got it last week. It has a category in it now. Section 7.03 is called Enemy Combatants. So it's working its way into our understanding of terrorism and the legal system. It's gaining stability but it's still in flux.
I have a question about, it seems that a lot of people disagree about the application of Article 3, and about 20 years ago there were statistics that, or there was information that Ronald Reagan had said that terrorists do not fall into the category of Article 3. Do you think it is worthwhile to argue whether they do or not, or whether to actually fill in the loopholes with an entirely new treaty regarding the new enemy of terrorism? If that makes sense.
Yeah. I think we have an answer to your question in some ways from the Hamdan decision. Hamdan makes it very clear, and I think they follow, whatever may be the critique of the Hamdan decision, they follow strictly the international law structure with regard to the application of Common Article 3. They find that it applies, and they were focusing on the provisions that had to do with the formation of a tribunal. So the military commissions didn't measure up, in their view, to the standards of Common Article 3. They found that Common Article 3 applies because the conflict we're talking about is this is a tough legal concept, is a conflict that is not of an international character. And that's the term that they use there. And what they said that has come to mean is that it covers all conflicts, not civil wars, but all conflicts. So, and that's a widely accepted view of Common Article 3. So that it means that as long as there's a conflict going on, Common Article 3 applies. It applies to Al-Qaeda, it applies to states that are involved in the conflict, it applies to everyone. And I don't know, maybe there's some military lawyers here who would speak to the issue, but I don't think most military lawyers would disagree with that construct of Common Article 3. And I don't think we need more definitions. I don't think we need a new treaty. There is a treaty that deals with purely internal armed conflicts that also deals a lot with insurgent groups or guerrilla groups. The U.S., it's one of the protocols to the Geneva Conventions, and we have signed it, but we haven't ratified it. And so some say we aren't obligated to follow it. Others say that the State Department along the way and the Department of Defense have accepted many of the provisions of those protocols as expressions of customary international law, the law of nations, the evolving practice of countries. And the International Committee for the Red Cross has found just that in its recent massive study of the law of war, a big, giant 3-volume treatise on customary international law. Now, the U.S. government disagreed with some of their methodology, but the U.S. was the only government to do that, and I think the study is widely accepted. So I actually think that much of the difficulties we got ourselves into around Guantanamo Bay had to do with our general disdain in this country, judges, lawyers, and otherwise, for international law, for the application of international law. But I don't think we can avoid it in this globalized era. I think we have to look to it, and we have to look to what is already out there.
We have time for one more question.
Thank you. Can you hear me? Sorry. I had a question actually about what you talked about, the protests that were going on the prisoners' part. And I was thinking about the sort of visibility versus the invisibility. That part of the problem certainly is that Americans do not have any access to the stories of the prisoners and what is happening there to them. And I had kind of a follow-on question about what's happened to the detainees that have since been released. there's certainly a critical mass, and I would understand if they'd want to distance themselves as much as possible from anything having to do with what they've gone through. But have any of them found any avenues of being of help to those who are still detained or getting involved in trying to make this more visible in some way?
Absolutely. And I appreciate the question. I think because of the national security regime that surrounds Guantanamo now, the stories of those who are still there only gets told through the voice of lawyers. If they correspond with their families. If they can't talk to the press, they can't get any access to anything else other than something that gets passed through a lawyer and unclassified through the security process that we have in order to tell their stories. And otherwise, we can't. Today, I understand I received a package of materials in the Garebi case, the new case that we took on. And it was filed in court, but the actual materials aren't available to the public. They're in a file in a secure facility in the Washington area. And in order to see it, I have to go there, say the secret password, get into the secure facility to look at it, and I can't talk about it once I see it. It's classified. And I think those are necessary rules that have to do with protecting our national security, and I'm willing to abide by them. Several of the detainees, I can think of two, Mozam Beg and Sami al-Hajj, who was a reporter for Al Jazeera, who was very active in advocacy on behalf of the detainees while he was there, and actually was the one who gave the name of Polad Sarajov to another lawyer who got his name out to the outside world saying he wanted to have a lawyer. Both of those men have, particularly Mozambique, a British citizen, has written a story about his time at Guantanamo and is incredibly articulate. I've been on a couple of panels with him, and when he speaks, I just pretty much let him have the floor, because nobody is more compelling than someone who has been there and can talk about it and talk about what they go through. So I commend his work to you. And there are a couple of books, too, about Guantanamo detainees that are culled sort of readings on their stories told indirectly through the correspondence with their families, the court filings on their behalf that have been done very well. So you have to look for it, and it is. I appreciate your comment about invisibility. There is a new book out by a woman named Michelle Shepard called Child of Guantanamo, I believe, about Omar Khadr, which I think describes me as looking like I was showing up for a backyard barbecue when I came to interview him, because I wore a guayabera when I was doing that, because it's hot in Guantanamo. And I don't know if I appreciated that characterization, but you know, that's the price you pay, I suppose, for your 15 minutes of fame. So thank you so much. I really appreciate your coming out.
On behalf of the Clarke Forum, Betty and Dan Churchill, and Dickinson College, I'd just like to ask you to join me once again in thanking Professor Wilson for coming tonight. This concludes tonight's event. Thank you for coming.